Okay, so this is our final video for synthesis. So now we're going to have a legal example. We're going to walk through a set of client facts, a statute, some cases, and go through this process of inductive reasoning to come up with a rule. And then you'll see a little bit of foreshadowing into how to communicate this analysis when you apply the deductive and analogical reasoning to it later. So this is the basic information that we have. Your law firm has just been hired to represent Rob Burr against a charge of armed robbery. He was arrested in connection with a recent robbery of a local coin shop. The owner of the shop is Numis Mattis. Mattis is a locally known coin collector. He buys, sells, and trades rare and valuable coins. He had arranged for a particularly valuable coin to be displayed at his shop for a promotional event, hoping that the exhibit would improve his sales. The exhibit received extensive coverage. So on the evening of July 15th, while Mattis was preparing to lock up his shop, someone burst into his office, pointed a heavy black wooden object at Mattis, and shouted, "Put your hands up, this is a shotgun, and if you make one move, I'll blow your head off." So Mattis complied. The intruder then swung the weapon back and forth in a menacing fashion and motioned with it that Mattis should get in the closet and stay quiet, or he'd get hurt. Mattis did as he was told and later told police that he'd been afraid that if he hadn't, that the intruder would either shoot him or strike him with the weapon. The intruder locked Mattis in the closet, took the coin, and left. Mattis was shocked and frightened by the incident, but was physically unharmed. So the question is, can he be charged and convicted with armed robbery? There we go. So here's our authority. We've got a statute. The statute says a person commits armed robbery when, with intent to commit theft, he takes property of another from the person or the immediate presence of another by use of an offensive weapon. So you've got several elements. This easily breaks down into elements. So we've got intent to commit theft, taking the property of another from the person or presence of another by use of an offensive weapon. Now, the first three elements are pretty clearly satisfied by his actions. However, it's not clear whether that cane that was carved to look like a shotgun is an offensive weapon or not. So we're going to look at these three cases. In each of these three cases, obviously there's no case directly on point. There's no case dealing with a shotgun, a cane shaped to look like a shotgun. So we're going to do what we did, remember, back in that formal reasoning video, where we had a rule that all men were mortal, but we didn't have a rule about women. And so here we've got a rule about certain other objects, but we don't have a rule about this particular cane shaped like a gun. And so we're going to have to use analogy to come up with this. So there are two things that we're doing here. The first one is that we're going to have to come up with a definition for offensive weapon, and we're going to do that through the process of inductive reasoning. Once we've come up with our idea or our articulation of the rule for offensive weapon or the definition for offensive weapon, the next step, which we'll get into in Module 2, is to then apply that rule to our facts, and because the rule doesn't specifically address canes shaped like guns, we're going to have to reason by analogy. And again, we'll do the reasoning by analogy in Module 2, but I wanted you to see how those things fit together. So first the inductive reasoning, and then the deductive or analogical reasoning. Okay, so in State versus Alpha, we have someone who robbed a victim with a starter pistol. In State versus Beta, we have someone who hit the victim over the head with a liquor bottle. And in State versus Gamma, we have somebody who robbed a bank with a toy cat pistol. So let's go on to that next step, where we go ahead and just look at each one of these cases and try to deduce from these cases what are the elements that are considered. What is it that courts look at when they try to decide whether something is an offensive weapon? So we've got our statute for armed robbery here. We've got it broken down into elements. intent to commit theft, takes property of another or from the immediate presence, and then use of an offensive weapon. Now, in this statement of the rule, I conflated two of those elements from the statute. Again, it doesn't really matter because those aren't the elements we're concerned with. And of course, there's always more than one way to break down an element. So we've got use of an offensive weapon. That's what we're most concerned with. So we have our basic facts from Alpha. We had a starter pistol. It was pointed at the victim. There was no evidence of striking. The court result was that this was not an offensive weapon. Now, when you're looking at these cases, you want to focus on the result for the case, the result for the court that authored the opinion. You're not concerned about what happened down below because that doesn't matter anymore once this court issues its decision. So it doesn't matter whether they overturned, whether they reversed, whether they affirmed, whether they remanded. None of those things matter. All that matters is what they had to say about offensive weapon. So this particular court said that this was not an offensive weapon, and the rationale was that it was not capable of producing harm as used. In Beta, the basic facts are that the defendant used a liquor bottle and struck the victim. The court's rationale was that this was an offensive weapon because of the way the defendant used it. So remember, just like with our curfew example, we're getting a little bit more of the rule with each case. So the first case gave us that an offensive weapon is one that is capable of producing harm as used. And then the second one gives us that piece that we have to consider how the defendant used it, not just how that object is normally used. Now, notice that in one case, it was not an offensive weapon. In the second case, it was an offensive weapon. It doesn't matter whether it comes up with the result that we want or the result that we don't want for our client. It still gives us valuable information about the rule. And if it's a case that comes to the conclusion that we don't want for our client, we can still use that case. You'll see that in Module 2, where we can distinguish those cases factually and still use them to support our point. Finally, you have Gamma. The basic facts were that the defendant used a toy cap pistol, pointed it at the teller. And one of the things that the court talked about quite a bit was the teller's response and the teller's fear. The teller was afraid, thought the robber thought it was real and not bulletproof glass, and he said, "Give me the money." The court ultimately found that this was not an offensive weapon, and they said, we're relying on the rationale in Alpha. Well, the rationale in Alpha was that it's not capable of producing harm as used. So because this was not capable of producing harm as it was used, pointed, then it's not an offensive weapon. Now, does that mean that we didn't get anything new from Gamma that we didn't get from Alpha? Not at all. We actually got some valuable information from Gamma. We have all those facts from our case where Rob Burr told Mattis to get in the closet and that Mattis said that he was really afraid he was going to get shot if he didn't comply with the instructions. Well, we know from Gamma that those facts don't matter. Those are not legally relevant facts. How do we know they're not legally relevant? Because even though the teller was afraid and even though the robber was threatening, the court still said it was not an offensive weapon. And if those things mattered, they would have come to a different conclusion. Remember, legally relevant or determinative facts are those facts that trigger the result. And these facts don't trigger the result. So that's why I've crossed through those facts about the teller being afraid and about the glass being thought to be real and not bulletproof, and then the robber saying, "Give me the money," because those things didn't actually impact the result. So the court has considered in all three of those cases the capacity of the object to produce harm and how it was used by the defendant. So notice again that the final three facts in Gamma were eliminated because they didn't matter to the outcome. Okay? So that means that an offensive weapon is one that contains those two elements. Remember, this is a synthesized rule. We're using inductive reasoning. So we're going to start with the elements and then we're going to articulate them as a rule instead of the reverse process, which we use with express rules. Okay, so now let's go to the synthesis chart. So we take those elements that we came up with, and we're going to put them across the top. Now remember, just like with to surf or not to surf, we're going to put the object in here. Remember, for surf or not to surf, we put the website. So we want to put the basic factual scenario as our first column after the case name. Then we've got the method used, capacity to produce harm, and the result. Notice that the result focuses on whether or not it was an offensive weapon. We're not concerned about armed robbery as a whole right now. Right now, we're just concerned about whether it was an offensive weapon. And so that's what we're going to center our result on. Okay, so we place all our information from alpha in there. In alpha, it was a starter pistol. It was pointed. And a starter pistol can't hurt someone just by having it pointed. Beta was a liquor bottle, struck the victim. You can hurt someone by striking someone on the head. So that was an offensive weapon. In gamma, we had a toy cat pistol. That was pointed. You can't hurt someone by pointing. Alpha already said that. So that's not an offensive weapon. And notice that gamma was the one that told us that we're not going to include in these columns things like fear or threats made. Okay, so in our case, Burr had a cane shaped like a gun. He pointed it and waved it and swung it. So as far as capable of harm, as used, in his favor, swinging is like pointing in motion. So if you're going to swing something, you've got to point it first and then just move it from side to side. And so you could say that this swinging is really just pointing in motion. And if we're not going to penalize someone for having an object that they point, we shouldn't penalize them for having one that they swung. An argument against the defendant is that swinging is actually the same motion as striking. You would argue that swinging goes side to side, whereas striking goes up and down. And therefore, because that motion is the same, it's just one is vertical and one is horizontal, it makes no sense to punish one and not the other. If striking makes something an offensive weapon, then certainly swinging should make it an offensive weapon. And notice that it doesn't matter whether or not the victim was harmed, because the court in Beta said the emphasis was on whether that object was capable of producing harm when used the way the defendant used it. They didn't say that it had to actually harm them. So you could argue that it doesn't matter that Mattis wasn't hurt, that swinging and striking are the same motion, and they can both cause the same kind of harm. So those are the arguments for and against. The result that we get, that's going to be completely up to the judge. But we have enough information now to put together a cohesive rule statement. So an offensive weapon is an object that is capable of producing harm when used as the defendant used it. So that's our rule that we apply to our facts, come up with our arguments. So in the next module, we're going to take everything that you've learned in Module 1 about reading rules, breaking rules down, using inductive reasoning to derive a rule, using the processes of deductive and analogical reasoning to apply rules to facts, and talk about how it is that you take all of that analytical work and then communicate it in a way that you can teach another law-trained reader what you've discovered through your process of analysis.